Michael Popok, Legal AF. Oral argument tomorrow in the United States Supreme Court on a major issue for Donald Trump. And according to reporting, Donald Trump is not planning to attend. Let me try to interpret what it means when Donald Trump doesn't attend something as major as the United States Supreme Court ruling and his 3 judges that he likes to talk about, the ones that he appointed, including the ones that Alina Habba said should do the right thing by him, including Brett Kavanaugh, because Trump stood by Kavanaugh during the confirmation hearing. What does it mean that Donald Trump is not going to be attending the hearing about the 14th Amendment, Section 3, disqualification of Donald Trump from the ballot? I can't even put too fine a point on this. It is a signal, as John Bolton, one of his former national security advisors, ambassador to the United Nations, said, it's a sign that Donald Trump knows he's on the losing end of the argument and could likely lose and doesn't want to be embarrassed as a result. How else to explain the reported, and we would know by now if he was attending, because to attend something like the United States Supreme Court oral argument with Donald Trump and a Secret Service in tow, there'd have to be an entire security plan implemented and placed in time, coordinated with the federal marshals, and that hasn't happened. And so I don't think it's by accident. Donald Trump and Stephen Chung, his spokesperson, or Alina Habba, I'm sure, will take to this the media, the social media, before this hot take probably post and say something along the lines of, President Trump is very busy in trying to win election as the leading candidate for office for the Republican Party, and the outpolling, even Joe Biden didn't have time to go to the United States Supreme Court, where they're deciding whether he should even be on the ballot. It is not a sign of confidence. If it is, it's misplaced confidence. Donald, this is going to be a dogfight. That's a terrible phrase. I'm sorry. This is going to be hand-to-hand combat at the United States Supreme Court. And he doesn't have it in the bag with the three support justices, Gorsuch, Kavanaugh, and Amy Coney Barrett, that he appointed, even with Alito and Thomas usually in his back pocket. The hearing, which we'll cover on the MeidasTouch network, is going to cover oral argument after full briefing as to whether the Colorado Supreme Court, 4-3, but a majority, got it right. That 14th Amendment Section 3 says what it says and doesn't say something it doesn't say. That the framers of it, the drafters of it, who are from the Civil War era, speaking to our generation today, it's future looking, wanted to prevent insurrectionist presidents from taking office. And the popularity of the president or the former president at the moment the brief is filed doesn't matter. I know they like to start, including a reply brief that Donald Trump just filed, which just shows the weakness of their argument, leading with the leading vote getter in the history of the Iowa caucus, Donald J. Trump. What does that have to do with anything? I'm going to say something here that I said on a prior hot take and at Legal AF. The founding fathers, the framers, the Civil War era that created a series of amendments to avoid future insurrection, rebellion against the Republic. South Carolina announcing they were going to secede from the Union because Abraham Lincoln was going to be inaugurated and slavery was going to be potentially outlawed under his leadership. They wanted to prevent that in the future and give newly freed slaves, now black citizens, the civil rights they sorely lacked. Now, having said that, they did not have a role for Congress other than taking away the disqualification if Congress so chose with a 2/3 vote. But the actual language of 14th Amendment Section 3 says anyone that's engaged in insurrection or rebellion against the Constitution is barred from holding office ever again. If he took an oath to support the Constitution, federal officer under the laws of the United States, and that's it. And as the 3-judge panel of the D.C. Court of Appeals just ruled this week, Article 3 judges, the judicial branch, has a role in interpreting constitutional law, constitutional provisions, and criminal law, of course, that comes out of Congress. That's the role of a series of, that's the role of judges in our constitutional democracy, in our republic. And so the oral argument is going to be about whether, A, right or wrong, Donald Trump's argument that the Supreme Court has no power to determine whether he should be on the ballot or not, and to determine the meaning and the application of the 14th Amendment, Section 3. I strongly doubt, although we'll see it when we hear it on oral argument, which is recorded audio, whether he's going to get enough votes in his favor to find that the Supreme Court and federal courts, who are Article 3 judges under the Constitution, don't have a role to play in interpreting the language of the Constitution. That's been settled law since 1807 in Marbury versus Madison, with the greatest Chief Justice of them all, Chief Justice John Marshall. I don't think they're going to say that. Question is, and they can't say that they can't figure out the meaning of the 14th Amendment. It has clear, express language from the Civil War generation drafters, and it has no role that's listed for Congress. Therefore, its silence has to mean that others are left to interpret it and determine whether somebody has engaged. It doesn't say convicted. It doesn't say that Donald Trump or somebody like him needs to have been convicted of engaging in insurrection or rebellion, because they could have written that very easily with their quill pen and their parchment. They could have written only if the person is indicted and convicted of the crime of insurrection or rebellion or something like it, can they be removed from the ballot. It doesn't say that. It says engaged in, leaving it to others to have to interpret it, human beings. So which human beings is it, Supreme Court? Is it state courts and state Supreme Courts? Is it secretaries of state responsible for the ballot? Is it federal courts all the way up to the United States Supreme Court? It has to be one of them. I'll tell you who it isn't. It isn't Congress, because that would have been easily written in by the drafters of the 14th Amendment, who also saw, in the same breath, saw a role for Congress in taking away the disability of insurrection and rebellion from somebody and letting them take office, but no role for them in the process of determining if they engaged in it or not. They could have set up a little court system through Congress, like an impeachment process, but that's not in the 14th Amendment. Donald Trump's got to know that even his most recent briefing that was filed by his new appellate lawyers, led by Harmeet Dillon, who was this close to becoming the Republican National Committee chairperson over Ronna McDaniel, who's on her way out. By the time February is over, she'll be out, because Donald Trump will have fully taken over the RNC, and he doesn't want Ronna McDaniel, so she's out. But Harmeet Dillon, in her briefing, is arguing that, first, Supreme Court, you have no role here, nothing to see. Article 3 judges can't review. It's got to go to Congress. That is against the weight of the textual, originalist language of the Constitution. Then they argue that he didn't engage in insurrection and rebellion. Well, the Jan 6 committee report and the evidence taken at the trial in Colorado begs to differ. All you got to do is read the 350 pages or so of the Jan 6 committee report, 6 months of work, dozens of witnesses, including all against Donald Trump, including his former lawyers and aides, video deposition testimony, thousands of pages of documents, and 3 terabytes or whatever of evidence says he did. And that is what these courts and secretaries of states have relied upon. That is the body of law to determine that he engaged. Again, the Constitution doesn't say take it through a court system, do an indictment and come out with a conviction and come back and talk to us. It doesn't say that. So somebody's got to determine that was engaged, and that was the special, select committee for the January 6th investigations role. That's why we had them. Congress did have a role, if you will, in generating that body of work. And then their other fallback is everybody who takes an oath, everybody, from dog catcher to cabinet member to every federal officer and every civil servant, everyone can be banned from the ballot under the 14th Amendment, Section 3, but not the president, especially if the president's name is Donald Trump. And have you heard he won the Iowa caucus by more votes than anybody in the history against, Ron DeSantis and the other ones? That's their argument. Popularism, popularity. Let me say something here that I've said before. An insurrectionist and a person who engaged in rebellion can also be really popular with one party. That doesn't mean he gets to go into office, right? I mean, I'm sure Charlie Manson was very popular with certain groups. Doesn't mean I want him to be our president. So that argument that the president is above the law is against the weight of the evidence in the legislative history around the passage and the drafting and the drafts and the red line and the changes to the 14th Amendment, Section 3. Plain and simple. So you can't swim upstream against the weight of everybody that drafted it who said the president is somebody that this would apply to, and then just say it isn't because it's not convenient for your argument. So then they fall back on the worst of their arguments, which is he took the wrong oath. Donald Trump never took an oath to support the Constitution. His oath was to defend and protect, and I don't know what they're even talking. I can't even get past the straight face test. Yes, commander-in-chief. He had a role to preserve and protect and defend the United States Constitution. You know what all those words mean at bottom? To support it. It doesn't mean not to support it. So, well, his oath's different. So that must be the drafter's intention, because they got different oaths, that he would not be subject to the 14th Amendment, Section 3, and everybody else is. Again, putting Donald Trump above the law in a constitutional republic that's based on co-equal branches of government and checks and balance. How do you have checks and balance if the executive branch is out of control? Who checks and balances him under their theory? So that can't be it. Look, this is going to be an unsavory position. They're going to hold their noses at the Republican side on there. But John Roberts is going to have to find a way, or he's going to go down in history as really the worst Chief Justice we've ever had, just a feckless, spineless person. If John Marshall is the greatest Chief Justice we've ever had, between the Dobbs decision taking away a woman's right to choose as a constitutional right on his watch, all the decisions destroying the separation of church and state, gun control out of control in this country because of John Roberts' court, and it will be known as the John Roberts Court, regardless of who's really running the show there. Now he's going to have to bring this ship into the port and find a way, not just for Donald Trump, but for our future, to find that the 14th Amendment, Section 3 says what it says. And the originalists and textualists on that Supreme Court, which are also the same Republicans, need to read what's there and apply it. And Donald Trump not being there is not a sign of bravado. If it is, it's false bravado. If he's not going to that oral argument, having gone to the D.C. Court of Appeals with his long red tie and his weird hair and sat behind John Sauer as he argued about presidential immunity, if he's gone to E. Jean Carroll and lost badly in the second defamation, rape, and punitive damages case, if he's gone, of course, to all of his arraignments, which, of course, he has to go to, if he goes to all of those, how does he not go to the Supreme Court's ultimate decision whether he belongs on the ballot or not? Because I got news for him. If he doesn't belong on the ballot and they say state by state people are allowed to make that decision for themselves, he'll be off the ballot in half the states. And the ones that have really large electoral vote counts. Look, we'll continue to follow what all this means with a reporting tomorrow on the MeidasTouch Network and on Legal AF about the oral argument at the United States Supreme Court. Let's see who leads. Let's see what John Roberts says. Let's see what Kavanaugh says, who in various concurrences and dissents and majority opinions has supported checking the power of an out-of-control president. Let's see now that the rubber meets the road where Kavanaugh sits. We know where Alito and Thomas sit. We'll see who's the driver for this oral argument and this hot bench. Is it going to be Ketanji Brown Jackson, who's starting to be the an intellectual leader on that bench? Will she come forward? Will it be Kagan? Will it be Sotomayor, who's been known to give it as good as she gets it at an oral argument? And who on the Republican right-wing side? Is Thomas going to peep up? Is it going to be Alito who's going to try to co-opt it and Bigfoot the argument? We know that Amy Coney Barrett's not. She'll ask a question or two. Kavanaugh usually asks a question or two. Gorsuch sometimes get involved. Or will John Roberts step up and put his brass ones, if he has any, on the bench and take control from the beginning to get the outcome that he's looking for? We'll find out on the MeidasTouch Network, Legal AF. Join me there Wednesdays and Saturdays at 8 p.m. for that leading podcast, The Intersection of Law, Politics, and Justice. And until my next hot take, until my next Legal AF, this is Michael Popok reporting.
Love this video? Make sure you stay up to date on the latest breaking news and all things Meidas by signing up to the MeidasTouch newsletter at MeidasTouch.com/newsletter.